Copyright disclaimer. Under Title 17 U.S.C. Section 107, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use. Okay, guys, this is from Oughton and Golden Law Firm. Dated November 29th, 2022. New legislation voids NDAs in sexual harassment and sexual assault allegations under federal, state, and tribal laws. On November 16th, 2022, the U.S. House of Representatives passed the Speak Out Act, which seeks to nullify some non-disclosure agreements, NDAs, in sexual harassment and assault disputes. The Senate previously passed the bill on September 29, 2022, and President Biden indicated he would sign the measure once it reached his desk. Rare bipartisan support 5 years after the start of the Me Too movement. The new legislation comes in the wake of highly visible claims against Harvey Weinstein, Roger Ailes, and other top-level corporate executives that sparked the Me Too movement. Doesn't this kind of remind you of all the rape kits that LAPD kind of didn't do anything with? Similar behaviors. It's my opinion. A wave of sexual harassment survivors pulled the curtain back on how companies use non-disclosure and non-disparagement restrictions, which initially these were meant for businesses, to force plaintiffs into mandatory arbitration and conceal allegations and settlements from the public. These agreements prohibited survivors from sharing their stories, exposing their assailants, and warning other potential victims. Reminds me of Scientology. Former Fox News hosts and Me Too activists Gretchen Carlson and Julie Roginski advocated for the Speak Out Act. Estimates suggest 1 in 3 private sector employees in the U.S. are subject to NDAs, which Ms. Carlson told Axios make you feel alone, like you're crazy, like maybe you're making it up. Does that sound like narcissism? Huh. She ultimately sued Ailes, I don't know how to say this, Ailes, settling the case for $20 million, but remains bound by an NDA even after Ailes was ousted from Fox News in 2016 and died a year later. Oh, you guys know. You know. Somebody didn't like her talking out. Giving survivors a voice outside of arbitration proceedings and the courtroom. The Speak Out Act is the second bill addressing non-disclosure restrictions in instances of sexual harassment and assault. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which President Biden signed into law in March 2022, bars companies from pressing plaintiffs in private, secretive arbitration proceedings. What about religions, Biden? What about religions? Together, the two statutes empower sexual assault survivors to seek their day in court, free of corporate defendants' heavy-handed silencing tactics. Or silenced permanently like this Ailes lady was. She must have spoken against someone that was powerful, and they had her taken out. My opinion. It's simply my opinion. Together, the two statutes empower sexual assault survivors to seek their day in court free of corporate defendants' heavy-handed silencing tactics. Too bad we couldn't do this for children too, huh? However, the Speak Out Act does have a few limitations. For example, the law only applies to NDAs signed before a sexual harassment claim is made. So in other words, they could have you sign an NDA after? I'm going to say what Serge says, make it make sense. Such as agreements that are part of a new employee hiring and onboarding. Unreal. I'm grateful I never went to a job that had me try to sign that stuff. I'm from the Gen X, man. I didn't have like some of these fancy schmancy like law jobs or anything. And shoot. The law importantly does not apply to settlement provisions or NDAs that plaintiffs might sign. You see that? I'm going to read it again. The law importantly does not apply to settlement provisions or NDAs that plaintiffs might sign to end a sexual assault claim. So to me, you know what that tells me? They can fair game, they can threaten and intimidate witnesses or women or men. And that's it. That's my opinion. The law is also vague. Of course it is. Of course you do want the law to be a little vague, don't you? I don't know. The law is also vague as to the definition. Yeah. You want it to be a little bit vague. The law is also vague as to the definition of dispute. Employers are expected to argue. What about religions? Can religions are their women and it's okay? I just want to know. You know, I didn't make it through algebra. Maybe I'm not getting it. Employers are expected to argue that dispute denotes only a formal legal proceeding such as a lawsuit or EEOC action, equal employment opportunity. At the same time, employee rights groups contend it includes an informal complaint. Oh, you know that doesn't go anywhere. I know that for experience. It includes an informal complaint to a company, human resources representatives. They're all in it together, you guys know. Only NDAs addressing sexual misconduct claims are covered. Not other workplace disputes. That makes sense to me, such as wage and overtime violations and race or age-based discrimination. Oh, they just completely described Scientology. NDAs remain an effective way to protect employers' confidential business information, including trade secrets, customer lists, and proprietary processes. Despite being the first legislation of its kind at the federal level, I personally think that just saying it applies to employment is a loop. That's my opinion. Because they sure didn't, they didn't cover religion, and then there's a lot of like, let's just say in the college setting, in the school settings, in the elementary schools, high schools, junior high schools. But I don't know, maybe they don't do the NDAs there. But I read something somewhere where they do a lot of NDA agreements in colleges now. It resembles state laws already on the books in California, Illinois, New Jersey, and New York. Maine, Oregon, and Washington have different statutes restricting employers' use of NDAs. That's where we're at, man. I mean, I do think it's good that it doesn't apply to sexual harassment or sexual assault. The only thing that bothers me is that it's only applying to employment. And let's just be honest, folks. Let's just keep it real. You know, if you have enough money, you can just get away with whatever. So, anyways, we could just do what we can. I'm going to put a link in the description box. Like and subscribe if you choose. Otherwise, have an amazing day or night, wherever you are. Peace.